Hi, welcome to the final video in this series of legal documents. We have a lot to cover in this last one, so I'll try to keep it as high level as possible, not go down too many bunny trails. But the big part that I want to talk about here to start out with are qualified retirement accounts. These are individual retirement accounts. Those are IRAs, whether they be traditional or Roth IRAs. And then we have employer plans, which the most popular common one is 401k plans. And then there's a bunch of there's Roth 401ks too. And then there, 457. There's just a boatload of other retirement accounts that fall under employer plans. That's what we're going to talk about here in the beneficiaries in there. The first thing I think is super important to understand, and people typically don't, really get this, but these are individual accounts. They are only in one person's name and one person's name only. So even if you're married, that's nope. These are individual accounts. So beware of that. And then we can kind of circle back up to when we talked about the durable power of attorney for property, including finances. You really should have your spouse named on the power of attorney so they can actually act on your behalf as an individual when it comes to these qualified retirement accounts. Super important. Okay? Now, the one thing I want to point out, and this is I don't know. To me, it's the most important thing, but this gets missed so easily, right? Is that we should name, in these accounts, we should name real people as beneficiaries. So, and I'll just go ahead and say, if you're going to name somebody besides a real person, okay, as a beneficiary, you really need to have a professional involved in that decision. Okay, an estate planning attorney, like it would need to be an attorney who really focuses on estate planning. And I guess I'll say that too about lawyers, attorneys. Okay, when they get their license to practice law, they can practice basically any type of law. That's fine. And then they may specialize in different areas. And so when I'm talking about an estate attorney, you really want to find an attorney who really specializes and totally understands that before you do anything different than naming a real person as a beneficiary. The other thing, this also has to do with taxes. Okay, so Congress has made some changes over the last few years where what used to be the way you could name beneficiaries in these qualified retirement accounts, they've changed some things that just took away some benefits that made, like making an estate or your trust as a beneficiary was okay. That stuff has changed. So just make sure you're talking to somebody who knows what they're doing before you do that. Okay. And I'm even I have to say this. I was working with a client and I was like, hey, listen, no, do not say that your beneficiary is your estate. That's not a good thing. So then I was like, okay, I just take 10 minutes and double check. I'm going to go log into my 401k and make sure I've got my, the beneficiary set up correctly. Just to double check, I'm sure I'm okay. Whoops. I had a contingency beneficiary as the estate. And that is not a good idea. You can start, there are some exceptions there. You can start out with, first of all, I'll talk about this quickly. You need to make sure you shouldn't disinherit your spouse in your retirement accounts, your IRA or your 401k. You shouldn't. And when I say you disinherit them, they should be, if your spouse is still alive, they should be your primary beneficiary. So you die, then that becomes theirs. They inherit your retirement account. There's a boatload of laws that help out that to make it much easier for spouses when they inherit. However, this is way beyond the scope of this, but IRAs are governed at the state level. 401ks and all these employer things are done at the federal level. Okay, and they treat, some states don't exactly line up with how the federal government does when it comes to employer plans as far as disinheriting spouses. I think I've even heard you disinherited spouse, but they put that spouse back in. A state may put it back in. So just because that's not what you're supposed to do. So just be aware of that. Ideally, you keep your spouse in there, and if you do get divorced, be on top of it real fast. You always hear, I know this is kind of clickbait sort of, sometimes you'll hear this, but it happens that a person intends for their 401k, to go to their children, and yet their ex-spouse is still in there, and they pass away, and the ex-spouse gets the money, and the children don't. So just be on top of that stuff. This is super important because I personally, for me personally, I love the fact that in these qualified retirement accounts, which for myself and and Jeff in our household, that's the bulk of our assets are in these qualified retirement accounts. And all we have to do is make sure we have our beneficiaries named appropriately in those accounts, and that's how it will pass. Okay? It doesn't go through the trust. It doesn't go through a will. It doesn't go through court. It just goes through those qualified retirement accounts. And I think it's pretty much this simple. Let's say we both go down on that cruise ship we were talking about. The cruise ship's gone, and then our stuff's at Fidelity. Fidelity says, "Hey, listen, I just got notified, probably within hours, how fast things can happen in this day and age with information technology, right? But within hours, Fidelity knows, hey, listen, they're gone. They're toast. We now have to go look at these beneficiaries and let's get this money out as fast as possible." It's just amazing. I love that. So, there's no lawyers involved, none of that stuff. It just, they get the notice of the death. They know that's happening, and the rest is history. It goes really fast. So I love that fact. You just have to have it right. You just have to set it up correctly, and that is very important. Okay. And I even I'm working with somebody, and they said, well, so just put make your primary beneficiary your spouse, and then just put the rest in the estate. Okay. So then what happens? Let's talk about that. You make the estate the beneficiary. So the estate is the beneficiary. So then our cruise ship goes down. We're both gone. It goes to the second contingent beneficiary, which is now the estate. Then that means it needs to go through probate. And all this money that's sitting in these qualified retirement accounts now goes through the court system, or goes through that process because it's in the estate. That's one step. We don't want that to happen. I don't want that to happen. Okay. So then the second thing is, if you make it your trust. Okay, so that's, that sounds a little better. It goes into the trust, and then the trust has language that says, okay, here's, again, like with the house and everything that goes in there, because they're a part of that. And now these qualified retirement accounts are now in the trust. Then we have just removed tax benefits. And I'm not going to get into that. It's way beyond the scope of this conversation. But you remove tax benefits, stuff that Congress just recently changed to go through and make that happen. And it's just not as good. The government will benefit. The beneficiaries will lose some advantages that they have if it had just gone to them directly instead of going through the trust. So keep that in mind. And also, when it goes into a trust, there's different taxation stuff that goes on. I get beyond the scope of this conversation. All I'm trying to say is here, at least having your beneficiaries in your retirement accounts and having those named correctly can just make things so much better. Okay, so I think I've gone on way too long about that stuff there, and I want to start wrapping this up. Okay, I want to go back to pets for a second. That is when again, it's all about going on a cruise, right? You're on a cruise, you got to have your pets taken care of. And that's just so important. And I searched years ago, I searched and searched, how do we take care of our pets? And I heard of Leona Helmsley, right? Maybe you all remember that, how she left several $1 million to her pet. And I know that made headline news, right? So how do we take care of our pets? Because that is, in my opinion, is super, super important. And I wasn't finding the right answer. So when we put our estate documentation together, I was like, we made a beneficiary, and basically talked to the beneficiary and said, hey, listen, we trust you, and our successor beneficiary for our trust, we'd say she comes pretty close to Mother Teresa, for example. I mean, it's just she cares about people and animals. It's very, very important. That's the important stuff. So uh, just please take care of these pets. Just make sure they stay in their home that they're accustomed to, or whatever. They just everything is perfect for them, because I'd feel bad if that's not the case. So that's what we wanted to do. Now, it was just a few weeks ago, I got this email from Joybound. Now, Joybound is an animal rescue in Walnut Creek, California, and we have a great friend who works there. We've done a lot with them. They've done a lot for us in this. And they said, hey, we're talking about wills and estates and stuff like that. Okay, so an attorney came. This was a Zoom call, and I listened, and I'm like, this was just like so amazing. I learned way more about how all this estate planning works, and when pets are involved. Okay, and honestly, it's given me a lot more confidence in what I'm telling you in these videos. That information. But the point I'm making is, if you have a pet, okay, and pets are property, they're not like human beings, like your children. They don't get treated like that. They are property. They're just like I don't know. It's it's like a bank account or something. They're treated like that. They're property. So we have these pets of ours that are now treated as property within the trust. You have in a trust, and you can even do it in a will, but you can say, hey, listen, I want somebody, whoever takes my pet, that they're going to get $50,000. I'm just throwing a number out there to take care of this pet. Just the outright gift. You can do that. Okay. And if you've got the trust, it can be given in there. Just say, hey, listen, the successor trustee, whoever takes this pet gets 50,000. Hopefully you've got somebody named. That's an outright gift. The next thing you can do is you can also set up the trust will stay alive while the pet's alive, and we'll just keep paying a certain amount of money each month or each year for whoever takes care of the pets. Okay, so that's another thing. And if you're doing something like this, okay, get yourself a lawyer. Make sure they know what they're doing. Just that's super important. But it can be done. That's my point. Is I didn't understand how this happened. Now I do. That's out there on the table. Joybound again, and I've checked out your location where you live for the animal rescue place, foundation or whatever it does in your area. They may have this where they have what I guess it's called a guardianship. And so for Joybound, I'm just going to talk about them for a second because this is where I learned about it. But you can say, hey, listen, in my estate planning, either through my will or through my trust, I'm leaving money to Joybound. And you can talk to them about how this is set up, or whoever it is in your neighborhood. Okay. I'm in the Palm Springs area down here right now in the wintertime, and I don't think they have it. I checked on their website for the Palm Springs Animal Shelter, and I didn't see it. But Joybound is a place that does. And you can leave money set aside for them to inherit the charity will. Okay. And then your pets, they'll take care of your pets. They bring them in, check them, and take care of any health needs. And then they find a new home that will be a perfect place for your pet. So that's another thing to do. Okay. Just we can watch for our pets. I think that's very important. Okay. I'm just going to start to wrap this up as quickly as possible. I do want to say, if you're like, oh, I need to do my estate stuff, but I know mine's kind of complex and I really need to do this and I need to do that, and you keep kicking the can down the road, okay? I'm saying let's just pull the trigger on something here. Something's better than nothing. And there are ways to do that. I just want people to be aware. So for example, if you're a member of AARP, okay, and if you're not a member of AARP, I recommend it. Okay, I know some people are like, not so much, but as a general rule, most people are say, hey, AARP is a good resource. And if you are a member of AARP, you can go look at their discount program, and they have this discount through trust and will Amazon.com. You can do a trust based. So this is an online service, and you can also add on a lawyer to review it. Okay, I'm just trying to say you can do something quick and easy for now until you find an attorney that you want to work with and make things, even more solid going through an attorney. But you can go through with AARP right now. I did some math. It was like $479 to get a trust based package with all these other documents, the General Powers attorneys, everything. You get all that set up, taken care of for $479. That's not It's not bad, I don't think. And at least you've got stuff in place in case something happens right away to you. Okay? So that's one. If you just need like I have a very close friend. I'm like, all you need, there's no house involved. Okay? There's no home. There's no real estate. But you need these power of attorney and you need a will. Okay? Very simple situation. And with this trust and will that's going through AARP, it's less than $199. And it's fast. And I know there's other options too, where you can just go in and, do an internet search or use your AI and say, hey, listen, I just need to put together a will, and whoosh, you can pop up with a document and it will tell you what you need to do. There are easy ways to do this stuff. They may not be perfect, but just like these videos, just do something. Just get them out. I know these videos aren't perfect, but there's something. I guess got to draw the line. That's where I'm going with that. You do have options. Finally, the thing that you have these documents in place, right? And you have accounts and you have all these assets and you have desires and wishes, etc. You need somehow to communicate that. I'm a little, this is a little too early for me to say this because I haven't quite implemented this, but I want people to know that these things are available. There's a thing called Everplan. I have recently, I got my iPhone app. It's you can do it online through on an internet browser. Okay, where you can they say, hey, load up your the copies of your documents, put them here, and whoever your successor trustee is, you make them part of your account so that they can get into this stuff and take care of all this matters. And it's all here, one stop shop in the cloud. I know that makes me nervous, but at the same point, it's like, where else is it going to be? Because when you do these documents, you'd think that I'm thinking, hey, the state of California, where do I load all this so the state of California can handle this? Not there. They don't. It's like you take these documents after it's notarized and you shove it in a safe, a fireproof safe. And then hopefully somebody knows when you pass away, they're going to look at that's the first place they'll look is in that safe. Okay, so that's that. Oh, by the way, don't put those documents in a safety deposit box in a bank. I hear that over and over and over because banks aren't too keen on opening up a safety deposit box for a person. Okay, there's a lot of things that need to be in place before they'll open it for just some random person or says that they should have access to that. Okay. But anyway, so this Everplan, and there's another thing. If you go to, say, for example, Amazon.com, there's a next of kin. You type in next of kin, and you'll see they have these like file folders. So this is for people who are very tactile. They want, everything's written down. It's a piece of paper instead of digital, right? So you can look at that as well. Those are other options. That's important. I haven't implemented that for myself quite yet, but it is something I am starting to do. And hopefully next time I do these series of videos, when I refresh them and make them just a little bit better, that I will have way more information on that. Finally, I want to, I guess there's one other thing I wanted to say. So as far as a trustee is concerned, back on your revocable living trust, you got to find somebody who you really trust and can take care of these things. Now, for us personally, we found somebody who we trust, we admire. I say like it's like Mother Teresa type person. They're really good, but they're not. That's being lousy at this as a actually taking care of this. They have no desire to be handling all this. But the point is, once they become the successor trustee, we're gone. The cruise ship is down. Okay, then they need to go find somebody to help to be a professional trustee. I mean, banks do it. You can hire a bank to do it. There are other places. There are also these, I guess they're called boutique firms, where they'll walk you through it. Or in our case, I'm given a name of a lawyer. Say, go talk to this person. They're going to charge you an hourly charge. Don't worry. There's money in the estate. There's money in the trust. There'll be money in the trust to use for that. Okay. So consider that as well. And I want to go back. Finally, let's wrap all this up. I want to go back to the very beginning when I was talking about we're gone. Our souls have moved on, but we can view what's going on. And this is where I think it is super important. Okay. So in our case, we're watching. Now we've got this living trust set up, and we have this person who's taking care of things. And she's going to be like, okay, they've got this all set up. I don't really have to go to court. I'm going to go hire, like I was just talking about, I'm going to go hire this attorney's, the name, and this attorney, she's going to help us walk through all this stuff. We don't need to rush off to court other than for the pour over will. All the stuff goes into the trust. I can handle this. I've got it covered. Okay. That's what I want to do. So when I'm looking on the other side, I'm watching this, everything goes easily. As opposed to other people, I hear this. Well, like, what? Who do I care? I'm dead. How many times have you heard all the horror stories of a person who is the executor of a will got named, whether they wanted to or not? They got to go to court. Court's got to say, hey, yes, you can do this, or maybe you're not qualified, or all these things. Try to keep the courts out of it as much as possible. And so it all follows the way that will make it much easier for the people who are handling your estate when you pass away. Thanks. I really hope this has been helpful to folks. It's a complex topic. I think I understand it way better than I did 3-4 years ago, but it's tricky. And again, make sure you talk to a professional before you take any serious action on this. Thanks again.